Sonny, can you hear me?
Yes, I can hear you.
Well, it's my distinct pleasure to introduce Sunny Singh, the head of Weil Gotshal's renowned restructuring practice. And Sunny recently rejoined the firm after a brief hiatus, and is working on some very interesting assignments. So I guess first, Sunny, what led to your return to Weil?
So, I started at Weil way back when as an associate in 2008. Grew up at Weil, and as you said, took a hiatus to try something a little bit different. Was really enjoying it, but got an opportunity to come home. And there were a lot of exciting things happening at the firm in terms of the types of matters we were working on. Obviously we've now filed First Brands and Fossil and a couple of other sort of very innovative cases and strategies that we've deployed. But the one difference really that helped bring me back, in addition to the people and sort of the friends I have here, is restructuring at Weil. Unlike many other firms, you sort of breathe restructuring at Weil. Like every department understands restructuring. Every department has worked on massive cases. So I can call a banking lawyer, litigation partners, capital market partners, and they've all dealt with restructuring before. Not just like touched it here or there. I mean, they understand restructuring, and I think it delivers a huge value to our clients.
Yeah, it's not you certainly wouldn't call Weil a boutique practice, but it's like the largest restructuring boutique in the world.
Yeah,
right.
Yeah, exactly. I mean, you can pull in. I mean, I joke with some of my M&A and like litigation partners and say, you guys are actually restructuring partners at the end of the day.
You just don't know it yet.
You just don't know it yet. So stop this M&A title, right, and just hang out with us on the restructuring floor.
Let's go. And so we can't talk too specifically about case matters, but
sure.
The First Brands, it's a very high profile one. It's a very interesting case. And I think I asked you before, there was this weird wave of fraud riddled cases that all happened in the span of a month last year. First Brands are the biggest, Tricolor, and then this Brombot, another one.
Sure.
So was that just a flash in the pan, and that was just a weird anomaly, and there's nothing to be read into it, or what is your take of this?
Yeah, look, I think there's probably lessons to be learned from those cases. I think it is a little bit ironic that not only the timing of when these massive fraud cases were happening, but the facts on them are, in some cases a little bit similar in terms of double factoring and things like that have been alleged between Tricolor and First Brands. I think what this really shows, though, is a couple of things. Probably not that, the private credits are, doomed for failure, but I think all of them have a common theme in terms of probably some lack of diligence, right? And some, look, you may never be able to diligence fraud, so I'm not criticizing anybody, but, the need for sort of heightened reporting, heightened governance, looking for more red flags and seeing if there really are issues out there, maybe you can protect yourself. But I think that, to me, is sort of the common theme through some of these things. I don't think it's systemic, right? Fraud, you hope it's not, right? But I don't think so.
But it's what can be done? I mean, I think in First Brands, it's pretty well reported and documented. They just had fake receipts.
Yeah, totally.
It was completely. How do you even guard against that? It just comes with the territory of this industry.
Yeah, I think, look, as I said, you may never be able to, diligence your way out of fraud. But there are certain situations and things where you look at some numbers, you look at the situation, and the math doesn't just add up, right? And so financials haven't been disclosed. And I'm not talking about any specific situation now, right? And so just the fact that you are continuing to get a coupon and, the money's coming in, but you're not really looking at information, right? It's like, don't be so passive in some of those situations. Again, not a criticism because, obviously nobody should be required to find fraud. But I think it's just also weakness in credits, right? You may not discover fraud, but you may just discover that, hey, this credit, some of this stuff doesn't add up, and should I be thinking about it differently? Should I ask more questions, et cetera?
I mean, back when I was covering that stuff pretty heavily, it led me to think that, especially with private companies, you're not just lending to a box that has a certain amount of EBITDA or assets or whatever. You're lending to a management team.
Sure.
You're lending to a group of people, and
Yeah.
you have to trust them to execute and to be honest with you. So I think maybe the First Brands fiasco has maybe led people to think about that more.
I think so.
You think so?
Yeah, I think so. I mean, look, I think there's, particularly with private lenders, right? I mean, they are sort of pride themselves on personal relationships, et cetera. And so I think you do have to take a closer look at those types of situations and see if you can protect yourself a little bit better.
Yeah. I mean, I just as Dan a couple, just a little bit ago that we've seen this massive growth in private credit over the last decade, and there are some signs that the asset class may have peaked. There's been a lot of redemption requests and gates going up and so forth, but we haven't yet seen it kind of bleed over into the restructuring space. There's just been a few one-off private credit workouts. But do you think we're going to see more of that, or it'll just get worked out more internally, or what do you think?
Look, what I would say is publicly there may not be that many private credit workouts, but they are happening with a regular rate of frequency. And they happen out of court, they're not public. I mean, there's a lot of reasons for that. I mean, for the one thing, relationships matter. Right, and creditors, private credit lenders who are constantly trying to lend to private equity sponsors are not going to want to be as aggressive potentially than they otherwise would be because this is sort of a little bit of a deal flow. Two, and to me this is the most significant factor, you can do an out-of-court restructuring, if you've got 100% lender consent because you've got one private credit lender, maybe it's a club deal and there's two or three. So it gives you a lot more flexibility to do workouts, not necessarily even take all the keys, but you can take, keys in a certain situation, you can extend the runway in a certain situation, maybe you can pump in a little more capital. And that's not all going to be public, right? And so it seems like, there was a couple of smaller public situations, but I think it's actually broader than that. That being said, I don't adopt the view that private credit is in some sort of massive wide-scale trouble given some of the redemptions and things have happened. I mean, I think it's just like any other industry, right?
You have a few bad apples, or it gets over the edges on some points, but there's not
right. And people are focused on how much exposure they have, to a particular type of credit, right? I mean, diversification, sort of like the 101s of investing, still apply, and I think that it's sort of a natural reset more than it is like this is an asset class that people should not be in.
I mean, what do you see as the primary restructuring driver this year? I mean, you have the stuff that you're working on, but what do you think is really going to trigger most of the action this year?
Look, I think LMEs will continue. I don't think LMEs are gone by any means because it is just another tool that people have in the toolkit for situations that make sense. I think there is also going to be some more unique transactions. I mean, we talked about during our prep, I worked on Fossil, which is an interesting transaction where it's a U.S., sort of public company, Fossil watches. Some of you may remember from your teenage days, right? And it's a U.S. public company, and we used a U.K. restructuring plan process to backstop the exchange. So really because the company didn't want to be and didn't need to be in Chapter 11 for a broader restructuring. So I think you're going to see more of these innovative types of structures and potentially going to other jurisdictions. So much of what we do in the world now is across borders.
What advantages did the UK system have that we didn't have here in the US?
So there was a couple of things. One, in the UK system, you can get third-party releases, even on a non-consensual basis. So there, we only, post Purdue, right? You can't sort of file and then get like a parent guarantor or a parent obligor released without filing that entity. In the UK, you can. I mean, they've been giving out third-party releases forever. We actually got the third-party release recognized back in the US post the UK restructuring plan.
But so they don't automatically get I mean, if it's a British third-party release, how easy is for that to get recognized here in the U.S.?
Yeah, look, nothing is easy, right? Especially when you're talking about third-party releases. But it absolutely matters that that it was an English proceeding, and U.S. courts and English courts have been recognized as decisions and cases and similar theories of law between each other for hundreds of years, right? So that goes into the calculus. But in the U.K., in a situation like this, that had an advantage. We only had to file, effectively a guarantor that really didn't have any assets. So you weren't putting an entity through a process that had an operating business and can have a lot of repercussions, as you know, in Chapter 11. And then the operating entities essentially got a third-party release that we got recognized back in the U.S.
So the third-party release was the primary driver of that process?
That was a big driver. Numerosity was an issue. In this case, Fossil had issued a bunch of baby bonds. And so you literally had $25 increments to a bunch of moms and pops, and we couldn't gather all the information. So if like 30 of them got together with like a plaintiff's lawyer and voted down a plan, in the U.S. we actually wouldn't have gotten that plan approved. In the UK restructuring plan, numerosity is not an issue. It's value of debt. And so there were a couple of advantages like that. And actually the fossil equity, if I think back to the numbers, I may have this a little bit off, but like public equity stayed untouched through the transaction. The absolute priority rule, you can actually just target pieces of debt in the UK as opposed to, hey, we got to deal with the absolute priority rule if we've got an objection. And so public equity stayed in place, and actually the value today, it went from like maybe sub $100 million to today it's at 260, right? The market cap of the company. Wow. And after having gone through the proceeding, they stayed totally in touch, didn't get canceled, New York Stock Exchange listed. It's a really interesting transactions. I think you're going to see New Fortress Energy is one that's been, followed that same suit. I think you're going to see more types of transactions where it's not just LME or Chapter 11, right? I think there's these
cross-border,
other jurisdictions that have really been trying to catch up to the U.S. Chapter 11 process and the advantages. And, not every company needs to do an LME or do a Chapter 11. Some companies may need to do something a little bit different.
So I guess Altice is probably the biggest and most famous large-scale cross-border LME, but you're sort of seeing the same thing happen in the in-court process too.
Sure, yeah.
Of mix and matching between different jurisdictions.
Yeah, I mean, look, First Brands, part of First Brands that doesn't get a lot of airtime is how much foreign operations that company really has. I mean, it's massive, right? And we had a whole team in London working around the clock to deal with, and they didn't file, right? But to deal with all of the foreign operations of the company, and dealing with various proceedings, various independent directors, local laws, local counsel. I mean, there was just a lot of different, and so and that's First Brands, right? Like a individually owned business. And so you're seeing businesses that are just massive these days, and the coordination you need between various jurisdictions is has to keep up.
Do you think that the U.S. Chapter 11 process is still effective for corralling all these different international claims?
I do. Look, I think I'm definitely biased on this issue. I think the U.S. Chapter 11 process is the best it gives you the most tools when you've got a difficult situation to create consensus.
But not every tool.
Yeah,
right?
But not every tool. And I think, a restructuring centered on a U.S. Chapter 11 process that can either go get recognized in other jurisdictions or you have tack-ons and things like that, I think is a huge advantage. And really the way, I mean, it's great to see because the U.S. Chapter 11 process has been upheld for so long and other countries are starting to follow a lot of what we do here because it works. It makes a lot of sense. It drives consensus, which is the objective. Then you have to think about recognition and getting to other countries and things like that. But I do think U.S. Chapter 11, even for foreign debt and foreign companies, makes, in some situations, a lot of sense. Yeah.
What do you think, is one reason why so many restructurings have shifted to LMEs?
I think there's probably a bunch of reasons. I mean, one, you hear a lot about the cost. When I think about that, I don't think it's necessarily like professional fees and professional costs. There is a business cost to Chapter 11 that really has to get taken into account.
And a reputational cost.
Yeah, reputational, right? Like customer relationships. Are you going to be able to pay, particularly because Chapter 11, particularly if it becomes like a messy process, right? And there's uncertainty, and that's why you try to get so many things locked down in connection with the filing of a Chapter 11 case. I think it's that business disruption that if it can be avoided, which you can do a better job of avoiding through an LME, is a big factor of why a lot of people or companies will gravitate towards LME. But if you look at the flip side of it, if what you're dealing with is really an operational problem at a company, an LME, sure, is going to buy time, is going to be helpful, but Chapter 11 is going to offer a lot more tools to actually fix the operations, right? That's what it's sort of designed to do. So it really depends on what you need for the particular situation. I don't personally think one is necessarily better than the other for a particular company, and therefore I would say always do an LME. or always go into Chapter 11. I think you have to look at every situation differently. What does this company need to fix? What's the creditor constituency look like? And then see the tools you have in the toolkit and figure out what makes the most sense. And look, you may end up in London like we did in Fossil, right? And everybody was like, the first board meeting, we had our English partner, Andrew Wilkinson, with an English accent. It was great. He said, I guess you're probably wondering why somebody with an English accent is on the phone talking to you guys right now. So, there's a lot of tools out there that I think we can use.
I think that the research shows that roughly 50% or 30% of LMEs do end up in bankruptcy anyway, which begs the question, is the purpose of the LME just to buy some more time and optionality, or is it just to better position lenders for when it does go bankrupt?
Yeah, look,
or it's a mix of the two.
Yeah, look, it's tough to say, right? I mean, because you see a lot of the ones that fail, and I think, as human beings, we're naturally drawn to that. The ones that succeed are not getting a lot of pats on the back because they've actually done it. I think one of the reasons LMEs end up in Chapter 11 is, keep in mind that when you're done with an LME, all of the sort of your capital, your baskets, your flexibility in the documents is shut off, right? And you've probably overcomplicated your capital structure to such an extent that it is very hard after having gone through an LME to do something else out of court. Not impossible.
Because it closes off so many doors.
It closes off a lot of doors, right? And that's why you usually get one shot at it. And again, that's not a criticism. That's just the function of the LME and sort of how it works. Certainly you can do deals where you get more than one shot. But after you've gone through that one shot, unless the company has recovered, it's tough to do something out of court in those situations. So I think it is just sort of, it's not that LMEs don't work. I think it's that one of the things, the price for an LME is flexibility is shut off in the future. And so it makes it more challenging to do something out of court on the second time around.
But it's oftentimes, from the debtor's perspective, it's worth it just to give it a chance, the optionality to see if it can avoid a court process.
Sure, oftentimes that's right? And if you can handle operational turnarounds and things like that without the court protections, then yeah, it's overall probably going to be better for you. But the question is, are you better off doing that, or do you just bite the bullet and fix the business and fix the cap stack, fully and get it court approved, or do you want to go deal with an LME and have litigation on the back end? So it's all puts and takes you got to think through and figure out what is the best, for a particular situation.
Right. And just one question about sort of how Weil and your practice sort of define itself in the market. I mean, some law firms are really focused on creditor side work, some are focused on private equity and sponsor work. Weil, I guess, dating back from the days of Harvey Miller, is known for advising on the messiest and kinds of companies where the whole thing is collapsing, and it's not sponsor driven, but it just, when there's a huge problem, they give you guys a call. So do you feel like you're a protege of Harvey Miller and try to carry on his torch, or what?
Look, Harvey was a close mentor. I got lucky enough. I literally, got assigned to Lehman Brothers my first day when I showed up to Weil, and by chance he walked into my office and gave me an assignment, and we became very close ever since. Harvey actually officiated my wedding. We were super tight. He was like family to me. He instilled a work ethic, an ability to approach things and think about things throughout the entire firm, not just me, and that continues to be today. Personally, I love, the messy, sort of difficult, complex cases. I think one of the reasons we get the call on those a lot is, where you and I started talking about today, you're not going to solve a massive international or even, massive U.S. company restructuring by just having a couple of good restructuring lawyers. You need M&A, you need litigation, you need tax, you need, people in London, people in Germany. We have all of that, right? And I know other firms do too, but we have all of that, and we have been working together, growing up together, doing those types of massive restructuring. So like the M&A partners that are, working on deals now, the litigation, we were all young associates at Weil doing this with, our mentors. And so we've been doing it together forever. And I think that those types of situations really have to bring all of these expertise together in these messy bankruptcies. And I think that's why we've been able to do a lot more of these than, than our fair share.
And it's sort of a little bit like a little bit lumpy because you can't predict there's going to be another First Brands.
Yeah,
but
yeah.
I guess something always
Yeah.
happens, and somebody always needs the help. And
Yeah, you sound like my CFO. He's always asking me when is the next massive First Brands. I'm just like, if I could predict that, I'm not sure I'd be working here. But
it's not that you're hoping for it, but
Yeah,
if they
you're
call you won't be upset about
yeah,
it.
no,
right?
exactly.
You know what? I think we have Judge Kaplan, the Honorable Judge Kaplan, is going to be on the next panel. So
I'm looking
we
forward
gotta
to
keep it
listening to
moving.
that.
But it
Yep,
was a
I
pleasure
appreciate
talking
it.
with you.
All right,
and,
you too. Thank you.
Great.